Okay, good afternoon, everyone. Welcome to the first session post-lunch. So,
Thankfully, the lunch was neutralized by this very exhilarating
yeah,
session we had just now. So, it couldn't have been better timed from our point of view.
oh yes, yeah, we have, I, all of us are energized and welcome to the post-lunch session. Okay, welcome, Mr. Manoj Mita.
Thank
I'm
you.
going to give a short intro about Mr. Manoj Mita with us here today. He's
Haven't
an,
I already been introduced?
yeah, I'm going to give a longer introduction.
Oh, okay.
Okay. So, Mr. Manoj Mita is an award-winning author, most recently of Caste Pride, Battles for Equality in Hindu India. His earlier books were on the impunity for the two most outrageous instances of mass violence in the Indian Republic, Delhi 1984 targeting Sikhs and Gujarat 2002 targeting Muslims. On the same pattern of impunity of for mass violence, whether politically inspired or based on social prejudice, his latest book was originally meant to be focused on the massacres of Dalits across India in the wake of the 1950 abolition of untouchability. But the evidence of structural bias underlying those atrocities pushed Mita to widen the scope of the book. Published in 2023, Caste Pride is a radically new history of caste based on the previously unseen legislative and judicial records going back for 2 centuries. The ambitious research stretching over 7 years was facilitated by 2 fellowships, one from the Washington DC based National Endowment Democracy and another one from the Bangalore based New India Foundation. Caste Pride has since won 2 awards for the best non-fiction in 2023, Atagalata Bangalore Literature Festival and Kalinga Literary Festival. It has also been shortlisted for Best Non-Fiction Award for the upcoming Valley of Words International Literature and Arts Festival at Dehradun. The book is currently being translated to Hindi, Tamil, and Marathi. For the wealth of new material brought out by him on caste and law, Mehta has spoken at several renowned universities in India and the US. These include the 4 leading universities of California, Stanford, UC Berkeley, UCLA, and UC Irvine. Caste Pride has received praise from academic experts. Mark Galanter, Professor Emeritus of Law at the University of Wisconsin, has written a blurb saying, with telling detail and incisive argument, Manoj Mitta's Caste Pride offers a fresh and penetrating addition to the literature on India's caste system and India's remarkable effort to regulate and transform it. A law graduate from Hyderabad, Mitta is a Delhi-based journalist focused on law, human rights, and social justice. He has worked in Times of India, India Today, and Indian Express. He is married, has a daughter and son too. Over to you, Ms. Manish. Yes. Oh, everyone wants to know whether a woman is married or not with a Mrs. title. So I make sure I'll do that for men.
Thank you so much for your generous introduction and mentioning that I'm married. Yeah. As she said, it is always tough to speak post-lunch. And what's going to make it tougher, I'm afraid, is the fact that I'm going to be reading my speech. Normally, I'm accustomed to speaking extempore, especially because whenever I'm invited, it is to speak on the very book I've already worked on for so many years. So I really don't need even notes. But then when Karthik invited me, where is he? When he invited me, I was under the impression that it was going to be one more time for me to speak on my book. But later when he made it clear that, that there was going to be an overarching theme for this gathering, for this conference, namely shaping American democracy. That intimidated me. That's not a subject that's quite up my street. So then we did a little bit of brainstorming to see what would be a subject that would be appropriate for a conference of this nature. And then we arrived at this. Civil rights in India and the US, legal parallels between Dalits and blacks. Though blacks and Dalits have had different trajectories of struggle on opposite sides of the globe, they have often been compared to each other. But how closely do the parallels between them actually hold? I will seek to shed light on this question by tracing some civilizational journeys, two each from the US and India. I deliberately use the word civilization because I noticed that this is an expression that has sort of been appropriated by the right wing, especially in India. So here is my counter to that. Needless to say, these journeys have had far-reaching effects on millions of people over the last 2 centuries. They have changed the ways of thinking and living on an unprecedented scale, challenging deeply entrenched prejudices, whether social, legal, or religious. Shedding the baggage of race or caste to whatever extent they could, they have been journeys of discovery, evolution, and emancipation. The 2 journeys from the US are obviously about race, and I'm sure both of them are in varying degrees familiar to the audience here. I say so because these journeys are so much a part of common knowledge in the US that they figure in your school textbooks too. By contrast, the corresponding journeys pertaining to caste are unfamiliar not only in the US, but even in India. Much of their details and significance have come out for the first time, I dare say, in a recent book written by me, the one she showed, called Caste Pride, Battles for Equality in Hindu India. As I narrate these journeys chronologically, the first 2 are from the US, the older democracy. Though my research and main concern is to tell you about the caste-related journeys, the race-related ones serve as reference points. The first journey began in 1776 with the American Declaration of Independence. For all the hype about the US being the land of liberty, the declaration drafted by Thomas Jefferson dwells on the principle of equality too, famously as a self-evident truth. In fact, those stirring words, all men are created equal, come even before the reference to liberty. About a decade later, when the Constitution was being drafted to put in place a governance structure, the Founding Fathers, however, downplayed the principle of equality. They could not wish away the reality of the time that America was deeply invested in an antithesis of equality, namely the institution of slavery. So much so that many of the Founding Fathers, including George Washington and Thomas Jefferson, were themselves slave owners. They could have glossed over this embarrassing contradiction, but for the dilemma they faced in regard to the composition of one of the 2 chambers of the Congress. While the Senate was going to have 2 members from each state, irrespective of the size, the House of Representatives was conceived to have varying numbers of members from each state depending on its population. So the question confronting the Founding Fathers was whether the large numbers of slaves working in the plantations of southern states should be counted, although they had no political rights whatsoever. Those blacks could neither vote nor contest in elections. This meant that the Founding Fathers could either confer equal citizenship rights on blacks or protect the property rights of white citizens to own or sell slaves. The compromise they arrived at in 1787 was 3 out of 5 slaves could be counted while determining a state's population size, which was for determining in turn the number of seats the state concerned could receive in the House of Representatives. This 3/5 compromise, as it was called, was incorporated in the Constitution, where slavery was tacitly admitted with a reference to quote unquote free persons, which was a euphemism for white people. Since a black was only 3/5 of a white, there was no question of equal citizenship. This kind of constitutionally sanctioned inequality maintained the status quo for 7 decades, notwithstanding the growing friction between free states and slave states. The matter came to a head when Dred Scott, a slave from Missouri, had, after taking refuge in the free states of Illinois and Wisconsin, sued for freedom for himself and his family. Rejecting his plea in 1857, the Supreme Court held that given his African descent, Dred Scott could not claim citizenship of the US, and therefore his temporary residence in a free territory did not bring about his emancipation. The outrage that followed this judgment was among the reasons that led to the Civil War, in the course of which President Abraham Lincoln came up with his historic Emancipation Proclamation on January 1, 1863. This proclamation served to change the Civil War from a struggle to preserve the Union to one focused on ending slavery. By the end of 1865, it culminated in the emancipation of the 13th Amendment to the Constitution, abolishing slavery. This was closely followed by the Civil Rights Act of 1866, which granted citizenship to all people born in the US, irrespective of race. But then, this well-intentioned law was vulnerable to being challenged on the ground of violating the 3/5 compromise enshrined in the Constitution. Hence came the 14th Amendment in 1868, repealing the 3/5 compromise clause in the Constitution. The equality clause established by the 14th Amendment also overruled the Dred Scott ruling that blacks could not enjoy the benefits of citizenship. Thus ended America's curious journey with its 3/5 compromise. This was followed by the 15th Amendment in 1870, guaranteeing that no citizen of the US shall be denied the right to vote on account of race, color, or previous condition of servitude. It may be noted that this reform ignored the ground of gender, because even among whites, the right to vote was limited at the time to men. The triumvirate of the 13th, 14th, and 15th Amendments to the US Constitution are called the Civil War Amendments or the Reconstruction Amendments. They are deemed to embody the founding of the Second Republic in the US. Thus ended the first of the 4 journeys I wish to talk about. If the first civilizational journey was from the 3/5 compromise to the 3 Reconstruction Amendments, the next one began in the wake of their enactment. The second journey is as revealing about today's America, in which a woman of Indian and Jamaican origins is contesting for the post of president. This journey began in 1896, when the Supreme Court upheld the replacement of slavery with segregation through a slew of so-called Jim Crow laws, which had been enacted by southern states. The context of the Jim Crow laws was the psychological inability of whites in southern states to come to terms with the idea of equality with erstwhile slaves, the idea of equality with erstwhile slaves, and thereby sharing any public space with them. Legitimizing such racism, the Jim Crow laws debarred blacks from, for instance, living in white neighborhoods or seeking admission for their children in schools attended by their white counterparts, or being treated in hospitals catering to white patients. As it happened in 1892 in New Orleans, a mixed race man called Homer Plessy dared to challenge such segregation by boarding a whites only train car. The litigation that ensued raised the question whether the policy and practice of segregation violated the equality guaranteed in the 14th Amendment. This set the stage for what has gone down as the most egregious judgment ever delivered by the US Supreme Court. It came in 1896 in the case known as Plessy versus Ferguson. Upholding the Jim Crow laws, the Supreme Court ruled that racial segregation was not discriminatory under the 14th Amendment so long as the facilities provided to blacks were equal in quality to those of whites. In other words, in the imagination of the Supreme Court judgment, the whites-only train car that Plessy had barged into was no better than the blacks-only train car that was reserved for him. The doctrine enunciated in the case came to be known as separate but equal. It took almost 60 years for the Supreme Court to overturn this doctrine and acknowledge that what was separate was inherently unequal. The provocation was what was then a routine decision for Kansas, one of the states governed by Jim Crow laws. It was the decision in 1951 of the public school system in Topeka, the capital of Kansas, refusing to grant admission to the daughter of a black man called Oliver Brown in the school that was closest to their home. Reason? That school happened to be reserved exclusively for whites. Though African Americans and colored people had long been reconciled to facing such discrimination in school admissions, the Browns mustered the courage to initiate a class action lawsuit. It led to a landmark judgment from the Supreme Court in 1954 in what is known as Brown versus Board of Education of Topeka. In a unanimous verdict underscoring the value of inclusivity, the court ruled that separate educational facilities are inherently unequal. As a corollary, the laws that imposed segregation in other spheres too were thereafter considered violative of the Equal Protection Clause of the 14th Amendment. Given that racial prejudices remained entrenched even after the US had emerged as a superpower in the wake of the Second World War, it took a mass struggle, the civil rights movement led by Martin Luther King Jr., for this judicial realization to translate into a ground reality across the country. There was a pushback from southern states against desegregation. So much so that within 5 months of proposing to provide legislative backing to the wider implications of Brown versus Board of Education, President John F. Kennedy was shot dead in 1963 in Texas. On the watch of his successor, Lyndon Johnson, the two chambers of Congress, honoring Kennedy's promise, passed the bill in quick succession within a year. Giving due recognition to the contribution made by champions of social justice, Johnson signed the historic enactment into law in the White House, as an iconic photograph shows, in the presence of Martin Luther King and his associates. Striking at the heart of Jim Crow laws, the Civil Rights Act of 1964 outlawed any form of discrimination, including segregation, based on race, color, religion, sex, and national origin. There was still a need, though, to pass another law the following year. It was the Voting Rights Act of 1965, overcoming legal barriers that prevented blacks from exercising their franchise. The gender neutrality of the 1964 and 1965 laws is thanks to the lead provided by the 19th Amendment to the Constitution, which came into effect in 1920, empowering white women to vote along with white men. Thus, for the blacks to enjoy in practice the civil rights that had been envisaged for them by the Reconstruction Amendments, it took a whole century of struggle and incremental reform. As I admitted at the outset, these two civilizational journeys of the US may be generally familiar to this gathering. Now brace yourself to hear about two such civilizational journeys of India that are, however, little known. These journeys began when India was still under the British rule, and they lasted long enough to spill over into the post-colonial phase. The first Indian journey I'm going to talk about began exactly a century ago in the southern province of the Madras Presidency. The context was an Indian variant of segregation, which was based on caste. It was called unapproachability, which was particularly rife at the time in South India. This was an offshoot of the countrywide malaise of untouchability, under which Dalits, members of the lowest rung in the caste hierarchy, were considered polluting and therefore condemned to live in filthy ghettos and without any sense of dignity. The trigger for this journey was an instance of unapproachability in April 1924 at a village in Salem district. The village was fortuitously called Kamalapuram. Trump would have probably called it Kamalapuram. Now the victim was none other than a newly nominated member of the Madras Legislative Council, R. Veerayan, who happened to be a Dalit. He was blocked from entering a road in Kamalapuram because it was passing through an exclusive Brahmin settlement, traditionally referred to as an agraharam. All that Veerayan meant to do was to visit the Kamalapuram post office and a nearby school, both of which were located within the boundaries of the agraharam. That he was still being treated with disdain for his birth as an untouchable prompted the Dalit leader to shoot off a telegram to the Chief Secretary of the Madras government. His protest caused a stir. Another Dalit legislator raised the matter in the Legislative Council, asking if Dalits were forbidden to walk through an agraharam, even if that happened to be the only approach to their destination. A more important fallout of the Kamalapuram episode was the initiative of yet another Dalit legislator, Rettimalai Srinivasan, in proposing that a resolution against untouchability and unapproachability be adopted by the Legislative Council. After a heated debate, the Council passed the resolution on 22nd August 1924, stating that, open quotes, there is no objection to any person or persons belonging to any class or community walking through any public road, street, or pathway in any town or village. Quotes close. Now that's something so obvious needed to be stated so solemnly through a resolution from the state legislature shows that Jim Crow laws, which were introduced only after the abolition of slavery, were the natural or organic state of affairs in India. About a month later, on 25th September 1924, the colonial government issued an order in terms of the Srinivasan resolution, Government Order number 2660, which served as the Madras equivalent of Lincoln's Emancipation Proclamation. Sure enough, Brahmins resented the idea of sharing their roads with polluting castes, as evident from a flashpoint in the Malabar district, which was part of the Madras Presidency. On 13 November 1924, a small group of low-caste Hindus, exercising their newly acquired right, entered an agraharam in Kalpatti village, which is within the municipal limits of Palghat. The occasion was an annual chariot festival, or Rathotsavam, which was open to visitors, subject, of course, to what was then a usual restriction on polluting castes. So despite the egalitarian content of the Srinivasan resolution and GO number 2660, the low caste members who had entered the public road of Kalpatti were assaulted and chased out by a group of Brahmins. This provoked a public outrage, all the more so because the government, in the teeth of its own order, had buckled under the pressure of Brahmins. It had taken action against the depressed classes rather than the Brahmins responsible for the breach of the peace. Despite the escalation of the caste conflict, Brahmins again had their way. They forced the government to issue a revised order diluting the earlier one so that Dalits were disabused of their newfangled notions of equality. The revised order, issued on 9th January 1924, went to the extent of clarifying that Dalits could not enter an agraharam if, open quotes, the entry is dictated merely by the desire to assert an abstract right and had no basis of business or of practical convenience. Quotes close. In effect, the desire of Dalits to witness the spectacle of the chariot festival was officially portrayed as an assertion of an abstract right. On the other hand, for the violence they had inflicted on those exercising their rights under the government order, GO number 2660 of 1924, the Kalpatti Brahmins were rewarded with exemptions through the revised order, GO number 37 of 1925. Such a surrender of the rule of law to religious bigotry about caste served as an impetus for Veerayan to think of something audacious. About a week after the GO on Kalpatti had been issued, Veerayan sent a draft bill to the office of the Madras Legislative Council. It was the first ever legislative proposal to take on untouchability, the first ever legislative proposal anywhere in India. The very practice of untouchability that the Brahmins of Kalpatti and elsewhere had for generations considered a pious obligation was redefined by this bill as an offence. As a corollary, the bill imposed a penalty, even if it was only a monetary fine. In legislative terms, it was but a baby step taken by a Dalit legislator to outlaw untouchability. On being granted permission by the Madras government, Veerayan introduced the bill in the Legislative Council on 31st March 1925. Even so, the objections raised against it required the intervention of the Viceroy in Delhi, Lord Irwin, who granted sanction for the bill to be considered by the Madras legislature. Subsequently, the Legislative Council referred the bill to a select committee, which went on to make a mixed bag of changes. Veerayan displayed remarkable tenacity in mobilizing support from diverse sections of the council. Finally, against all odds, the bill was passed on 31st August 1926. At the time of the passage, a fellow legislator named J.A. Saldana called Veerayan's legislation, open quotes, the crowning glory of his self-sacrificing and noble activities on behalf of the depressed classes inside and outside this council of the last 3 years. Quotes close. The civilizational breakthrough made by this 1926 enactment was noticed contemporaneously by the media too. The Bombay-based Times of India, for instance, called it a great achievement by Veerayan and said that, open quotes, it should go a long way to remove many of the social disabilities, quotes closed, faced at the time by Dalits. A recent American equivalent of it is the first ever law in this part of the world against caste discrimination. It was the one passed last year by the Seattle City Council at the instance of a Brahmin called Kshama Sawant. The feat pulled off by Veerayan in 1926 inspired central provinces, which included parts of today's Maharashtra and Madhya Pradesh, to come up with a similar law in 1933 with provisions defining the offences of untouchability and imposing penalties. This legislation too had been piloted by a Dalit. It was G.A. Gawai. Yet, neither of these pioneering laws against untouchability, piloted by Dalits themselves, was acknowledged in history. That is, until my book set the record straight last year. This blatant erasure of the legislative contributions made by Veerayan and Gawai exemplifies the proverb that history is written by the victors. Another way of putting it is that our history books reflect the narratives of dominant interests. So the legislation that is popularly presented as a trailblazer is the one that was passed by the Madras legislature in 1938. That is, full 12 years after Veerayan's quantum leap in the same province. And this 1938 legislation is generously credited to the then premier of the Madras presidency, Chakravarti Rajagopalachari or Rajaji, who happened to be a Brahmin and one of the leading associates of Mahatma Gandhi. The omission of the Veerayan and Gawai precedents helped historians sidestep one major deficiency in Rajaji's enactment. Whereas the Veerayan and Gawai laws criminalized untouchability, the Rajaji law was merely declaratory, with no penal consequences flowing from it. The Rajaji law just declared that no court would recognize any custom or usage relating to untouchability. Since it did not define any offense, there was no question of any punishment. Thus, far from building on the precedent set by little-known Dalits, the law that was valorized by historians, the Madras Removal of Civil Disabilities Act 1938, was conceptually retrograde. Shortly thereafter, in 1939, the Congress government of the Bombay presidency came up with a bill that wittingly or otherwise, preferred the Veerayan-Gawai model over that of Rajaji's. The bill was introduced by Home Minister K.M. Munshi on the watch of Premier B.G. Kher, and both of them happened to be Brahmins. Though it defined offences of untouchability and prescribed penalties for them, the bill suffered from a basic problem which forced Ambedkar's Independent Labour Party to oppose it vehemently. The problem was that the bill did not make any of the offences, quote-unquote, cognizable. This meant that the police could not register any case under the proposed law. Instead, it placed the burden of securing convictions entirely on Dalits, who were required to hire private lawyers and file private complaints before a magistrate. Ambedkar's position was that as Dalits were largely indigent and ignorant, the proposed law would have no practical value unless the offences were made cognizable, thereby entrusting the police with the responsibility of investigating caste atrocities. As it happened, Kher was so averse to the Ambedkar camp's suggestion that he called it, quote unquote, a bad remedy and went to the extent of dropping the bill. It was only in 1946, in the run-up to independence, that the Kher government finally accepted Ambedkar's logic that Dalits could not be expected to have the courage and resources to take on their oppressors belonging to dominant castes. The belated incorporation of the provision making untouchability offences cognizable betrayed a structural bias among the elite Indians who were then taking over the reins of governance from the British. The proceedings of the Constituent Assembly that followed provided another little noticed evidence of this structural bias against Dalits. While several founding fathers and mothers of India participated in the debates pertaining to the abolition of untouchability, Prime Minister Jawaharlal Nehru was completely missing in action in those debates. Though untouchability was as integral to the founding of the Indian Republic as slavery was to the founding of the American Republic, the Nehru government took 4 long years to come up with a central bill that was supposed to provide teeth to the constitutional provision against untouchability. For all the support that Congress party had received from Dalits right in the first general election of 1952, Nehru did not think it fit to participate in the discussion over this bill. The one who instead went through the motions of piloting the bill was Home Minister Kailashnath Kadju, who made no secret of his Brahminical notion that untouchability was not worthy of being punished. In fact, Kadju claimed that Dalits were ambivalent about making untouchability a punishable offense for fear of causing bad blood in their villages. Thus, even as a nascent republic in 1954, India was in spirit still where Madras was in 1938 when Rajaji balked at going beyond a declaratory law against untouchability. One indication of the Nehru government's reluctance to be tough on untouchability was that besides having mild provisions for imprisonment, its bill had no qualms in offering monetary fine as an alternative, which meant that instead of imprisoning the convict, he could just be let off with the imposition of a monetary fine. The violent crime of untouchability was reduced to a petty offense like a traffic violation that was punishable with just a fine. A comparison that Ambedkar once made between slavery and untouchability may help us understand the structural bias at work in Hindu India. In a work titled, "Which is Worse, Slavery or Untouchability?" Ambedkar gave several reasons for his conclusion that untouchability was worse than slavery. One of them was that unlike slavery, untouchability was justified by its perpetrators on the ground of religious compulsion. Slavery was never obligatory, as evident from the contrasting positions taken on that institution by the whites in the northern states and those in the southern states. But there was no such choice among caste Hindus when it came to untouchables. They were enjoined to keep away from Dalits to avoid pollution. Hence, the reluctance of the Pandit Nehru government in 1954 to frame a law commensurate with the gravity of untouchability. The underlying presumption was that a caste Hindu committing the offense of untouchability could not have had any criminal intent. He was merely fulfilling his pious obligation to maintain his purity or following a custom handed down over generations. In the light of the structural bias betrayed by Hindu India, even after the much touted abolition of untouchability, It was no surprise that the subsequent escalation of mass violence against Dalits was met with a pattern of impunity. Despite the apparent stringency of the more recent provisions against untouchability, Dalits have received little by way of justice. This is mainly because some arm or the other of the Indian state, the police, the prosecuting agencies, the trial courts or the appellate courts, have shielded the culprits or discounted the caste angle on the flimsiest of grounds. Now I'll tell you briefly the story of the last of the four civilizational journeys I have in mind. This pertains to the traditional bar on untouchables across India from entering temples. If the earlier journey was essentially about barriers to accessing public places in the secular realm, this one was squarely in the religious domain and was therefore even more sensitive. Gandhi's own trajectory on temple entry bears testimony to the extent to which someone as great as him had internalized caste prejudice. On becoming the unrivaled leader of the Congress Party in 1920, Gandhi was instrumental in placing the fight against untouchability as one of the priorities of the freedom struggle. Yet, for the next 12 years, he remained stuck in the contradiction of being opposed to temple entry as an unabashed votary of Varna Vyavastha, the scriptural prototype of the caste system. It was only after he had blackmailed Ambedkar into signing the Pune Pact in 1932 and giving up the hard-fought right of Dalits to a separate electorate did Gandhi open up to temple entry as a reciprocal gesture owed by caste Hindus. Even then, he was opposed to an across-the-board rights-based approach and instead advocated an incremental or gradualist approach. This was to ensure that only such temples could be thrown open to Dalits where local devotees expressed their willingness through a referendum. Gandhi called this local option formula, under which temple entry was no entitlement of Dalits, but only a charity extended at the discretion of local caste Hindus. Thanks to such a grudging attitude, it was only around the time of independence that various states enacted laws that made temple entry a matter of right for Dalits. But this belated concession made little difference on the ground, as Dalits still had to struggle on a case-by-case basis to assert their right to enter temples. For lack of time, I will cite only one example, which may in fact resonate with you. This is because it relates to Swaminarayan, an influential sect from Gujarat, which built temples not only in India, but also other countries, including the USA. And I noticed that AKSC happened to intervene in a labor violations case against a Swaminarayan temple in New Jersey. It would therefore be apt to recall this little-known irony that the Swaminarayan sect had fought in the courts from 1940s to the 1960s to be exempted from the ambit of the temple entry laws. In a bid to save its temples from its deep-seated fear of pollution, it contended that the legal reform meant to throw open Hindu temples to Dalits did not apply to the Swaminarayan sect, claiming it was actually a separate religion. Much to its disappointment, the Supreme Court ruled in 1966 that Swaminarayan was very much a sect of Hinduism and was therefore obligated to let Dalits inside its temples. To make sense of the lengths to which the Swaminarayan sect went to prevent Dalits from allegedly contaminating its temples, one should keep in mind the slow evolution of Gandhi's own outlook on this issue of religious sensitivity. The point of juxtaposing these two caste journeys with the two race journeys is to help appreciate the pathologies of the two largest democracies. In the case of India, though, there is the additional complexity of Brahminism increasingly operating in recent decades under the guise of Hindutva. But that's another story for another day. Thank you.
An enlightening journey.
I hope I
Doing it.
didn't overshoot my time limit too much.
That's a
Or did I?
yeah. No, not a lot. Yeah. Thank you. And it is a very interesting to know the parallels that are like very, very similar. And also I was mentally deriving the parallels for gender. Okay, that's my own thing. So, so when you said the BAPS issue, they are actually operate here as a Hindu thing, and they
So do they in India. It's just that when this question of letting Dalits enter their temples came about, they were so desperate to keep Dalits away from their temples that they went to the extent of claiming that they were not Hindus at all. And that was just to circumvent the law. It was to avoid that.
Yes, it is a very similar offense that they made here, because in their construction of temples, whoever they exploited, labor exploitation happened mostly to Dalit people who were brought in here in the guise of artisans, and they were made to work in dangerous conditions, and that case is still on. I think nobody wants to comment about it. So it is a it is a lot of parallelity that we could observe.
Artisans
Yeah.
would be typically from Dalit Bahujan.
Yes, definitely. And so okay, I will start with my question, and then we will go over like one or two questions together. Is that okay?
Sure.
Okay. So the civil rights movements in the USA typically defined as between 1954 and 68. Yet the struggles and the rights issues are very much alive, and the challenge have only grown by time, and it is growing more and more right now. So despite the numerous grassroots movements emerging, we don't label the period as a movement period per se. So why is that, and what needs to happen for the grassroots efforts to become a mass movement of like capable of shaping the legislation in the current situations?
Sorry, I didn't get your suggestion that the phase dealing with the civil rights struggle is not called a movement. Is that what you were saying?
That period is not called a movement per se.
I thought it was known as civil rights movement, the one that was led by Martin Luther King, in which somebody like Rosa Parks participated, and there were so many flashpoints in various states.
Oh,
Is that
you,
on that? Okay.
Keep the comment short and maybe a question.
Yeah, I think when we talk about periodization of movements in U.S. history, it's now, if we think of the first Reconstruction following liberation from enslavement, and till 1877, and then the civil rights movement is now by current activists thought of as the second Reconstruction, and what's been going on since the uprisings in Ferguson is thought as the third Reconstruction. So that's just another way this could be framed with the periodization of mass movements.
Sure. Thank you. Thanks for your intervention.
yeah. So my another question is like, for what do we want to do like for the grassroots movements to become mass movements, so that it would have the power to change the policies and legislation to that level. So
Okay. I'll go back to your first question before I come to the second one, because it gives me an opportunity to explain where I come from. To my mind, your first question was about semantics, the term that could be used. My background is of journalism. My focus is on telling stories, and those stories are based on archival material in this particular instance. I mean, normally we use with contemporary issues. So very often we do a lot of field work. But when it came to this work on caste, as you said in the introduction, my original idea was to write on violence, mass violence targeting Dalits, beginning with Kilvenmani in 1968 in Madras. And then there have been a whole lot, especially in Bihar and elsewhere, Maharashtra and Andhra. And a lot of these happened in my lifetime. And as a journalist, I did have occasion to deal with them, write about them, critique the justice or whatever was passed off as justice in those cases. So, but then when I got into that those cases, I ran into this pattern of impunity, and I felt the need to understand where this structural bias was coming from. And that is what prompted me to go to archives, which is not normally the place that we journalists go to. It's something that's normally visited by academics. And why did I have to do that? Because the existing literature did not answer my question about where this structural bias was coming from. So that made me want to find out for myself, do primary research, not something that I was trained for. And to my surprise, I found that there was a wealth of unexplored material dealing with law and caste. As she said in the introduction, a lot of them were pertaining to debates that took place in legislatures and courts. And I thought they were very revealing about today's India. It would help you understand that these unfinished battles are what explain why the system, the legal system, despite all that rhetoric about the constitutional values of equality and so on, get away with such impunity, right? It was all just rhetoric. It helps you understand. And it's not of recent origin. It was always the case. There was always a gap between the rhetoric and reality. And it was so revealing. And that's how I ended up going into this domain of academics. Now, why am I going into all this? It is to say that does not mean that you should now mistake me for an academic. I'm still only a journalist. I'm still only a storyteller. I'm what they call in Indian terms a katha vachak. I'm not a pandit. So I can't hold forth, I can't theorize, I can't tell you what should we do with this knowledge because I don't have a background in activism either. I'm just a journalist. The value of my work, I believe, lies in making you aware of things that were gathering dust, material that was overlooked by people who were actually trained to bring that out. One possible explanation, one is that maybe this kind of neglect betrays the class bias or caste bias of scholars. That's a possible explanation, but another could be more innocuous, which is that these scholars are mostly from the background of sociology, anthropology, history, or political science. Now, I represent a confluence of law and journalism. I'm accustomed to dealing with a lot of technical stuff, and my challenge has always been to demystify those legal intricacies and present them in the form of stories that are accessible, that are engaging. So maybe that's how I ended up bringing out this new material, so much new material in the book. So this was a very long answer to a very simple question, or two of your questions, because there was a pattern to your questions. The first one was about semantics, and the second one was asking for gyan from me on how in the light of all this material, I think I could energize the grassroots activists. I have no answer to that. In fact, when I'm doing my storytelling also, I try to keep my own biases as much as possible out of that. I let facts speak for themselves. I don't opinionate, I don't theorize. And there's a good reason for that. Because as journalists, we are trained to let readers decide for themselves whatever they can with that material. And I have enough humility to believe that each reader will read into that material nuances that might not be in my consciousness at all. And that has indeed been my experience over the last year or so. So many people come up to me and tell me, okay, this is what it is. And that would be so enlightening to me. I only told you what I know from the records in archives. But what those what that implied, or what are those gaps in between that, the way readers fill those gaps is very enlightening and enriching to me. And those things, I think, would actually be prejudiced if I were to be nudging the reader in a certain direction and telling him to look at it the way I'm able to see, rather than leaving it open to diverse readers to come up with diverse interpretations and nuances. So that's been my approach. Sorry.
Well, thank you for going to that archives. That gave us a great deal of details about the law. So,
and in fact, there was so much of that unexplored material. I love mentioning this too at every gathering, at every opportunity, that this thick, fat book that you saw is not the only one. There's so much unexplored material that I couldn't accommodate it in one volume. I'm currently working on another volume because there was so much material. And I promise you there's no overlap between the two. So it's not as if I'm regurgitating stuff because this one was fairly successful in terms of creating a buzz. No, that's not what it is. There's a whole lot of new material which will be coming up in my next volume. So that's to give you this magnitude of neglect as far as this legal aspects of caste are concerned. Why do I mention legal aspects? Because caste is otherwise a subject on which hell of a lot of academic work has been done. I go to a library like in Delhi. I'm Delhi-based. So the biggest library there is Nehru Memorial Library, which these days is called Pradhan Mantri. A lot of institutions have been changed, so it is now called Prime Minister's Museum, something. So there are shelves upon shelves devoted to caste. And yet, there's hardly anything on this crucial interface between law and caste. Although that determines so much of what's happening on the ground, and that helps you understand so much when you look at it through the lens of law. The finer details, they come out in the course of these debates. And some of you I understand have actually read. So you would understand what I'm talking about, right? Thank you very much. Yeah.
thank you, Manoj. So we can please raise your hands if you have your questions. Is it okay?
Hi, I'm Amulya. Thank you so much for that talk. Really, really interesting to hear about those legal precedents, which have not really been in the scholarship and they're new to me. I have a question that's relating to sort of this parallel in these two different forms of law in the US and the United States and these precedents for civil rights law in both the context. So part of what was so interesting to me about what you named is the way that since, the time of these individual cases you described, there have been efforts by caste elites to continuously pull contestations over caste from the public sphere and the domain of the state and bring them back into private life, right? It's culture, it's my personal choice, it's religion. And there is such a history in India from colonial times because of customary law, because of religious law that allows that to sort of have a foundation. It resonates with people. It makes sense in a way that if someone made the analogous claim about practicing white supremacy because it's their religion or culture, even though people may be doing that, that claim doesn't resonate here in the same way as I think claims to personal religious choice do in India on account of like a very particular history. So my question is, with respect to the fights we're fighting here right now around getting caste into, anti-discrimination laws in California and the US, trying to move these contestations over caste discrimination here in California into the domain of the state as something the state should be investigating it they should be bringing it, before the civil courts. It should be something that is a public process, not something we have to just adjudicate privately in our communities. How do you see that same, rhetoric, that move to say, people here saying, oh no, I practice caste, it's my religion, it's my right, it's personal, it's private, it's an Indian cultural family issue, right? It has nothing to do with the state of California. And how do we take these lessons from the parallel you're showing and think about what do we need to do to put this fight back at in the public state level, right? At that jurisdiction, and fight these efforts of folks to keep pulling it back into the private sphere, since it's, what do you think we should do about that?
Sure. Though I personally prefer answering immediately after the question is put because it's fresh in my mind.
Please go ahead.
Okay, thanks for your indulgence. The thought that crossed my mind as you were putting your very beautiful question was, sorry, I was not using the mic. Was I still audible? Yeah. There's this chapter in my book on intercaste marriage. Why do I mention that in the context of what you just now asked? Is because, what that chapter shows is that it was in the year 1918, someone known as Vithalbhai Patel, who was none other than the elder brother of Vallabhbhai Patel, who belled the cat in terms of introducing a bill seeking to legitimize intercaste marriage, which was considered illegal, and their children were illegitimate and so on, right? So he very strategically cites examples from upper castes to show that this is not something that affects only these wretched lower castes. So it is in the collective interest of Hindus, the enlightened self-interest of Hindus, to address this question. And it does not belong in this age that there should be such a restriction. It's unnatural and so on and so forth. Even so, there was a pushback. From who? From the Hindu right of the time. And where was that Hindu right? This was in the year 1918. So the RSS and all was yet to come into existence. And this Hindu Mahasabha was still at a very nascent stage. So the Hindu right that pushed against this proposal of Vithalbhai Patel was Congress leaders. Congress was a big tent. So you had people like Madan Mohan Malviya, Surendranath Banerjee. And what is the kind of rhetoric they came up with? It resonates with today's rhetoric in the context of protecting their right to religion. What did they say? These were not exactly their words, but in spirit, they were essentially saying, Hindu khatre mein hai. Why? I mean, Hindu religion is in danger if you let, these kind of intercaste, intervarna. In fact, there is this expression that is used even in Bhagavad Gita. What is that? Varna Sankara, right? Arjuna says, if you let this war take place, then there will be this kind of miscegenation. There will be so much of intermixture of castes. Can you think of anything worse than that? Right? So that's the kind of rhetoric these guys, these leaders, Malviya was no mean leader. He was by then already twice or thrice president of Congress Party. He went on to become president of Congress Party again. He had by then established Banaras Hindu University. And soon after Modi came to power, that way, within a year, he conferred the highest civilian award, Bharat Ratna, on Malviya to undo this historical injustice of this man's contribution not of going unrecognized. So, but when you look at the fine print of these legislative records, you will realize that this is the kind of contribution he made. This is the kind of objections these orthodox Hindus, represented by Malviya, was raising, right? So, my answer to you again, it's the kind of answer a journalist can give. That's all he can say, is awareness. If only these kind of stories, it took, because of the opposition made by people like Malviya in 1918, it took repeated efforts by reformers. And who were these reformers? They were also Hindus. And they were not necessarily lower caste Hindus. Some of them were Brahmins. And it took 30 years for for that reform to be finally enacted. 1918 it was started, and 1949 it was enacted. And when it was enacted in 1949, I'm happy to say that it was because a Brahmin from Punjab, Thakur Das Bhargava, was the one who piloted it. Why do I mention it? Again, for a strategic reason. Because I don't want the Hindu right to get away with the claim that this is all about some subversive lower castes who were not being respectful enough of our scriptures and of the legally sanctioned hierarchy and so on and so forth. We have any number of instances of upper caste Hindus, Brahmins themselves, who found the caste system not only retrograde but untenable, and they were themselves engaged in making these reforms. Right? Here is one example. And talking about freedom of religion, since that was what you were referring to, the provision in the Constitution is Article 25. Now, I love to mention this also because there's this clause 25(2), which says that freedom of religion and conscience in the Indian context does not mean that any upper caste person, I mean, that's why an upper caste, it can only be an upper caste person because of the nature of what this provision is talking about. It says that nobody can say that this is violative of the freedom of religion. And what is that? That any effort, any attempt to reform Hinduism, any attempt to have, reform Hindu institutions, meaning temples. What they had in mind was that by the time this provision was being debated in the Constituent Assembly, there were already several attempts to throw open temples. Temple entry laws were enacted at some places against all odds. So they didn't want freedom of religion to become an excuse for these orthodox elements to say that this is something that is against the traditional way of doing it. You can't let these polluting castes enter temples and ruin the atmosphere there and tarnish the solemnity of that place or take away the purity of that idol. Apparently, if a Dalit comes close to an idol, these are the kind of arguments that they came up with in those debates, that it will lose its sanctity, right? So, conscious of all those kind of arguments that were actually made in legislatures, it took a Brahmin who's actually also a Hindu right-wing hero. I'm talking about K.M. Munshi, the founder of Bharatiya Vidya Bhavan. So I'm mentioning this for a very subversive reason. It was none other than Munshi himself who was instrumental in the introduction of this clause in 25(2). It was not Ambedkar. It was an insider. It was a Brahmin who knew the kind of objections, the kind of mischief that Brahmins could come up with, that Munshi said that we need to have this kind of a safeguard. We need to say that freedom of religion does not mean that you can come in the way of carrying out such reforms in Hindu institutions, namely letting Dalits enter temples. You can't say, I have this freedom of religion, so you don't let, Dalits enter. So I'm sorry, I again give you a very elaborate answer, but that's how it is. Thank you.
Thank you, Manoj. Yeah. I think in the interest of time, we will go for the break
I'll try
now.
to be brief. And I can't keep track of time as you do, Biju. Sorry.
Okay, so you probably could discuss with Manoj. Okay.
Okay, two questions, I'll be brief, I promise.
My name is Vivek, and I want to maybe challenge some of the methodology that you've used. For example, when you talked about the American context, you're really focusing on laws that are being implemented by the people in power. But I think you're missing some of what's leading to that. For example, during the years when slavery was broadly legal in the United States, there were a number of slave rebellions where enslaved people rose up, killed the plantation owners that were seeking to keep them in power, and in some cases succeeded. The Emancipation Proclamation was only enacted by Lincoln when he was faced with the problem of Union armies going into the South and meeting thousands of formerly enslaved people who had left plantations and didn't know what to do with them, and forcing that issue on Lincoln and the Union armies. And in many cases, before the proclamation, they re-enslaved them. And the reason I bring this up is I'm curious if you can talk a little bit about Dalit resistance in India that is not done through courts or government mechanisms, but is actually much more on the ground, being led in analogous to these rebellions that have taken place in the United States, which I'm more aware of. And if you can address maybe some of the limitations of working through these archives or government documents as opposed to information that may not be captured in those places, that may be passed on through oral histories, for example. Thank you.
Hi, Manoj. I'm Mario. So you mentioned that you are a journalist and not an academic researcher. So I'm just wondering how you make sure you're like politically accurate, because there's another journalist, an African American journalist, Isabel Wilkerson, who wrote a book on caste, the origins of our discontent, and which got made into a movie. I find her theory of calling it's just not racism, but it's casteism. She says that what the African American community faces is not just racism but casteism. I find that problematic because they're not similar or even symmetrical, right? So how do you? I mean, and the movie was even endorsed by a researcher that I admire, Dr. Suraj Youngday. So how do you make sure that you're politically accurate, and how do you see this take by Isabel Wilkerson?
Thanks. So I love that question. What I share in common with Wilkerson is that she is also a journalist. But then she went beyond the confines of journalism, and what she did was what academics typically do. She theorized in suggesting that racism is so bad that it is that she likened it to caste. Yeah. So when I am dealing with any of these issues in my book, I made sure that I don't go beyond just storytelling, because my material was so rich. In her case, I think the problem was that she was dealing with something which is also, extensively covered already. So she probably was under pressure to come up with some such audacious theory to appear to be saying something very dramatically new. In my case, I didn't have to do anything. Just my material, by default, was all new. So I didn't have to embellish it with any theory. Just let the facts speak for themselves. I hope I answered your question. So it was all based on what? The gentleman here was talking about oral history and all that, right? It was not any of that. It was based on archival material, and even in archives, it was not so much private papers and all. It can't get more official or more authentic than that. It was all legislative records, court records, right? So we were all very rigorously documented. It was not somebody's notings in a diary and things like that. Much less was it oral history, or this book was based on archival research, not on field research. So there was no scope for me to, or need for me to do any oral research. So I don't know if I can answer your question satisfactorily. But yes, uprisings were there even in India. And the most famous one, an uprising needn't be violent. Given the kind of prejudice that was there, even something as basic as scooping water from a water body in Mahad. Is that poster still here? I saw. Yeah. So there was that picture of Mahad Satyagraha. It happened in 1927. What was it? It was an uprising. And what did they do? All that they did was just scooped water. Now you might say, how is that an act of violence? But from the point of view of the existing system of Brahmanism, that was violent because they had no business to go anywhere near that water body. And that was an act of subversion, right? So, and interestingly, that was followed by such swift action from the colonial administration. They booked those who were engaged in violence. I'm not referring to Dalits who gathered there to draw water. That action of subversion was met with violence from caste Hindus of Mahad area. So those who engaged in violence attacking Dalits were immediately booked, and within a matter of 2 or 3 months, literally, they were tried and convicted. I mean, that kind of action is unheard of or unimaginable in today's India. I mean, you won't even have the will to do anything like that, right? So all these, these are the kind of things I focus on because they're all well documented and they are useful, but they don't get enough attention. Not the one I cited. I mean, this particular case was very well documented by Anand Teltumde in his book on Mahad Satyagraha. So I don't deal with that. I focus strategically on areas which were missed out by existing literature. That was my whole approach. So that's where it starts. Thank you.
Thank you. Thank you very much, Manoj. It's a pleasure moderating your session, and we got to know a lot of legalities and stuff which are missed out. Thank you, everyone, for your questions and being attentive post-lunch session. Thank you, everyone.
So before we
have a
close,
break
there's a
now.
wonderful talk. So there's a saying that paranoid will survive, meaning that how the Hindu community is so paranoid. Say, for example, with respect to SB 403, the people said that if you're a Hindu, the cop will pull over and give you a ticket and ask for whether you're Hindu or not. That is their claim. But the Hindu phobia people said that if you're a Hindu, you'll pull over. So that's how they are paranoid to keep up their position.